Good morning, everyone. Welcome to the second day of our October case call. We will call the first case, which is People versus Terrance. Counsel, you each have 15 minutes. Mr. McCreedy, I assume you'll try and reserve some of that for rebuttal, and you may begin.
Thank you, Your Honor. Yes, I'll keep track of my own time, of course, but I'd like to reserve 3 minutes for rebuttal. And may it please the court, my name is Dave McCreedy. I'm representing the people in this matter. I'd just like to begin by reminding the court of some of the final instructions that were given to the jury in this case. In closing instructions, the judge said, remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. The judge continued, as jurors, you must decide what the facts of this case are. This is your job and nobody else's. What you decide about any fact in this case is final. To sum up, it is your job to decide what the facts of this case are, to apply the laws I give it to you, and in that way to decide this case. When you decide this case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. The lawyer's statements and arguments and any commentary are not evidence. They're only meant to help you understand the evidence and each side's theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. Again, you are the only judges of the facts, and you should decide this case from the evidence. Make your decisions only on the evidence that I let in and nothing else. You should use your own common sense and general knowledge in weighing and judging the evidence. But you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. Now, unless the jury was not supposed to follow those instructions, then it was open to them to decide this case on a basis other than the parties' theories. Now, for issue preclusion to preclude us from pursuing this torture case, the defense has to show that there was no other rational way to decide this case other than the people's or the defense theory. And as I just indicated from these instructions, the jury was instructed time and time again that they could decide on a basis other than the parties' theories. That's number one. And number two, there was a reasonable view of the evidence that they could decide on that didn't involve identity, but the defendant's intent. And as long as there is any rational basis to decide this on intent rather than identity, then issue preclusion does not apply. In that case, the people should be either granted leave to appeal or the Court of Appeals should be reversed and this should be remanded for us to go back to trial. With that, I would invite any questions from the court.
Thanks, Mr. McCreedy. I'm going to start with Justice Cavanagh. We're taking turns on ordering here. So,
Yeah, I don't have any questions this morning.
Justice Markman.
Thank you. I don't have any questions now either.
Justice Zahra.
Well, thank you, Mr. McCreedy. You'd be a great trial judge. You did a nice job reading those instructions to the jury.
I practiced. Thanks.
Ash v. Swenson, right? That's what controls here. Is it your
Correct.
position? Is it your position that if the evidence could conceivably be based upon that evidence, if any jury could conceivably reach that result, or is it that they could reasonably reach that result?
Yeah, the point in the defense brief is well taken. I mean, in a case where the charge has 5 elements, you could say conceivably they could have decided on any one of those, and in which case it would be that exception would swallow the rule. That's not what we're claiming here. Conceivably is the word used by the U.S. Supreme Court. It's not something that I interjected in this case, but clearly what they mean is reasonably, rationally. And so it has to be supported by the evidence. It just can't be, here's one of the elements, and we don't know in a general verdict state like Michigan is what they decided on. And this is not a novel concept under the law. Trial judges, time and time again, have to decide whether a rational basis supports a requested instruction. And then appellate courts have to decide whether the trial court abused its discretion in making that determination. So all the court has to do is follow people v. Gillis in that line of cases to say, could a reasonable fact finder have found based on the evidence? And in this case, there is plenty of evidence to show he didn't intend, he didn't have malice for murder. He called 911. He was distraught on the phone call with 911. He was doing chest compressions. He rode in the ambulance to the hospital. He told one of the ambulance drivers, "I didn't mean to take her last breath." The jury could certainly consider those facts along with the uncountable number of non-fatal injuries that when the medical examiner did the autopsy, she was surprised to find none of them was more than superficial. None of them were fatal wounds individually or in combination. So all that evidence together, the jury could say, look, he was putting his hand over her mouth to terrorize her, but he didn't have the intent to kill. He did not have malice for murder. And in that way, we're going to find him not guilty of the murder, but we could still find him guilty in this case of the torture.
Thank you.
Justice Viviano?
I have no questions. Thank you, Mr. McCreedy.
Justice Bernstein?
No questions, thank you.
Justice Clement?
No questions right now. Thank you.
Mr. McCreedy, I have one. So it does add up to me that a jury could have concluded that the defendant did not act with intent to commit great bodily harm. But in a torture prosecution, isn't one of the elements that the defendant has the intent to cause cruel and extreme physical or mental pain and suffering? And isn't that a problem? Those intents seem the same. So isn't there a preclusive effect and a problem with that overlap? What's your thought? What are your thoughts on that?
The jury was instructed on second-degree murder. So the only time that they were instructed about great bodily harm was under the second-degree murder, lesser included. And when the instructions were read, the intent to do great bodily harm was specific to the smothering. In other words, the jury was never instructed to consider the non-fatal wounds to her body in terms of torture, or whether or not he had the intent to do great bodily harm as related to those wounds. The instruction was specific that he caused the death by smothering, and that in that act he had the intent to do A, B, or C, one of which was the intent to do great bodily harm. So even if great bodily harm is the same in the murder statute as it is in the torture statute, and I don't think it is, and I'll address that in a second, but even if it is the same thing, it only applied to the smothering, not to the beatings. And so we could at least go forward on a prosecution theory that he applied these beatings so extensive that the ME couldn't even count them.
But I mean, there's a way the jury could have concluded he had no intent in the smothering act, but did have the intent in the beating act.
Right, they could have said he had the intent to do great bodily harm in the beating act, but they were never given the option under the instructions to make that determination.
Okay, I understand. Mm-hmm.
But also, I mean, if you look at for number one, they were all they were told in terms of great bodily harm was those words. It was never described to them what that meant. The torture statute has a very specific definition of great bodily harm. And so the two, while they sound similar, great bodily harm and great bodily injury, they sound similar, but they're not the same because the statute defines very specifically great bodily injury. But on top of that, that's an alternative. The torture statute allows us to prove torture through severe mental pain or suffering. And the jury never considered that one way or the other. So that would be left open to us in a torture prosecution.
Thank you. Do you want to reserve the remainder of your time?
If there are no more questions, yes, please.
Okay, so reserved.
Thank you.
Ms. Meneses, is it Meneses? I apologize if I am botching your name.
It's Meneses, Your Honor.
You may proceed.
Thank you. Good morning, Your Honors, and may it please the court. Angeles Meneses from the State Appellate Defender Office on behalf of Treshaun Terrance. During closing arguments at Mr. Terrance's trial, the prosecution told the jury, "I submit to you that the only issue you may have in your mind at this moment The only element that you will have to deliberate when you go back into that room is whether or not the defendant did it. The focus of Mr. Terrance's trial was identity and whether Mr. Terrance was the perpetrator of a continuous assault culminating in Ms. Tillman's death. The jury's verdict decisively determined that Mr. Terrance was not the perpetrator of this assault. The Court of Appeals correctly applied well-settled United States Supreme Court precedent in both Ashe and Yeager and found that the torture charges were precluded here. If Mr. Terrance can't win under Ashe and Yeager, then no defendant can. Opposing counsel argues that if the test were to be applied as intended by both Ashe and Yeager, that the exception would swallow the rule, but that is not the case. The issue preclusion test is meant to be applied practically, looking at the evidence, pleadings, charges, all relevant matters, not technically and restrictively. To apply it technically and restrictively would lead to a complete rejection of the issue preclusion test as established in Yeager. I am open to the court's questions at any time.
Starting again with Justice Cavanagh.
I have none.
Justice Markman.
No, thank you. I have no questions either.
Justice Zahra.
Questions, thank you.
Justice Viviano.
No questions. Thank you.
Justice Bernstein.
No questions.
Justice Clement.
No questions.
Let me ask you the same question I asked Mr. McCreedy, Ms. Meneses. And more specifically, let me ask about his answer. He makes a good point that the jury did not consider at least part of the mens rea element in the torture statute, the intent to cause mental harm. Do you share his view on that? And is there anything else we should be thinking about when comparing the mens rea overlap?
Your Honor, that is correct that the jury did not consider the mens rea of the torture charge because the torture charge was not in front of them at the time of this trial. That was not at issue for the parties to decide either way. The only element that was at issue when taking a complete look at the totality of the circumstances here, looking at the opening and closing arguments by the parties and the evidence presented and the way the cases were presented, both parties' theory of the case, the only issue and element here was whether Mr. Terrance was responsible for this continuous assault that was always argued as one continuous assault, not two separate acts that culminated in Ms. Tillman's death. And because the jury decisively determined that he was not the perpetrator of this assault, that stops that torture charge from being brought in a new trial.
Are there any additional questions for Ms. Meneses? Thank you, counsel. We'll go back to Mr. McCreedy for your rebuttal.
Well, Your Honor, all I have to say is that I agree that this trial was fought on the grounds of identity, and that was the crux of both parties' theories, but that is not the end of the analysis under Ashe. So given that the evidence supported an intent verdict rather than an identity verdict, we have to win here. And that's really all I have to say in rebuttal unless there are other questions.
Are there additional questions for Mr. McCreedy? Seeing none, I want to thank you both. The case will be submitted.